Okay, hello everyone. Uh, Welcome to our monthly webinar with Badmus Associates, immigration options for entrepreneurs. Thank you so much for attending this webinar. Before we get started, I just want to be sure that we have all the technical aspects in place. So I want to make sure that you hear me. So if any one of you hear me, please put in the chat box, yes, you hear me. Perfect. Thank you so much for your quick response. Okay, as I mentioned, today's webinar is related to those who are interested in immigrating or obtaining legal status in the United States based on business. So before we get started, a few housekeeping rules. I want to let you know that you can ask questions at any time, and the way to do that is to use the Q&A bubble that you might see at the right of your screen. There's a little bubble that looks like a question mark. That is the Q&A panel where you should type and send your questions. The chat feature is for if you're having any technical difficulties, something like that, you can use that. But please use the Q&A panel so we can track your questions more easily and respond to them. Also, for confidentiality, make sure that your questions are general, provide no personal details, because this is an open forum, so we want to make sure that your confidentiality is kept, your information is kept confidential. So just some background on us. If you're not familiar with Badmus Associates and this is your first time attending one of our webinars, we are an immigration law firm that has helped thousands of clients gain legal immigration status in the U.S. since 1993. We have been lucky to be awarded one of the best law firms in the United States for immigration, and also have been placed on the best lawyers list as well as the best lawyers in Dallas list. We are located in Dallas, Texas, but we can help clients nationwide. Also, before we get started, I just want to remind you that this is a presentation for informational purposes. It is not legal advice. This is general information, so it should not be relied on specifically for your case or your matter. If you have specific questions or specific case that you want to get evaluated, then we suggest you consult with one of our immigration attorneys or another qualified professional. So with that said, let's get started with the presentation. So before we go on, I just wanted to give very basic facts, which I like to explain to people when we're talking about entrepreneurship. So basic immigration facts to know about whether or not you can do business in the United States. So first and foremost, we want you to understand that visa legal status is not necessary if you are what's called a passive owner of a business. So passive meaning that you're simply buying a stock of a U.S. company. You might own a house or pretty much a house, a real estate, which is not meant for the purpose of maybe meant for the purpose of generating income. However, you're not actively involved in that. Or if you're borrowing money for any purpose as well, even if it's for business outside the U.S., if that's possible, then visa status or legal status is not required. However, if you want to be actively involved in a business in the United States and live here and work in that business in the U.S., then that sort of self-employment or doing business is considered employment and does require work authorization from the U.S. Citizenship and Immigration Service. So we're going to talk about those options where you actually can be self-employed in the U.S. And by no means it's not comprehensive, because there could be other options that just in the time that we have, we're not able to discuss. But the options we will discuss will be ones that are more commonly used for business owners. So when we talk about options for legal status, we're going to talk about generally two different types of options. One is what we call temporary visa. So the picture here kind of depicts what you might see in your passport if you received a temporary visa, non-immigrant temporary visa. And those are visas that allow you to be in the United States for a specific purpose and for a specific time frame, and must usually need to be renewed in order for you to continue with that purpose and that work in the United States. An immigrant visa, or what we call a green card, is permanent status. So if you receive an immigrant visa, then you are allowed to live and work in the United States in any legal manner for as long as you would like. There is no limit. There is no requirement for renewal. So obviously those who have a more permanent intent to be in the United States would want to eventually look at, if not immediately look at, an immigrant visa option, which we'll discuss as well. So just a quick overview, and we'll talk about these options in more length as we go through the presentation. So these are the typical immigration options for entrepreneurs. They're not necessarily limited to entrepreneurs. It can be other occupations or professionals that can use some of these visa options. But these are options that entrepreneurs or business owners can also use in order to live and work in the United States. So we'll talk about the O1 Extraordinary Ability Visa, and the counterpart to that is the EB1A Extraordinary Ability Green Card. We'll also talk about the EB2 National Interest Waiver Green Card, and then talk about the L1A visa, and the counterpart to that is the EB1C green card. And then finally, we'll go through some of the more specific business related options, which is E2 and E1 treaty visas and the EB5 immigrant visa green card program. And then finally, we'll touch on the international entrepreneur parole rule or program, which is kind of a unique program designed specifically for startups and business owners, and is not actually a visa option. It's sort of a different animal altogether. So we'll talk about that towards the end. So starting with the O1 and EB1 extraordinary ability criteria, the reason why I have both O1 and EB1A combined here is that the criteria is very similar. Both require that the applicant is considered, quote, extraordinary ability alien, which must demonstrate that they are considered to be one of the considered to be at the top of their field of endeavor, whatever that might be. So in the case of business, if you are a tech entrepreneur, for example, you are considered to be one of the top tech entrepreneurs in your country, or even internationally. So that might be the O1 or the EB1A might be options for you if you can prove that specific criteria. But the difference between these two, there are a few differences, even though the criteria, as we'll demonstrate, is very similar. The O1 is a temporary non-immigrant visa, which initially can be issued for 3 years and then indefinitely renewed in 1-year periods, unless you change positions in some way. The EB1A is the immigrant visa, as I mentioned earlier. This is permanent residence or the green card itself. So that's one specific difference. And if someone gets an O1 visa, it doesn't necessarily translate into an EB1A visa. It's to get an EB1A green card, you would specifically have to apply for that EB1A and again demonstrate your eligibility. And as the USCIS likes to say, it's not automatic. It does not mean just because you have an O1 visa does not mean that the USCIS will agree that you also qualify for an EB1A visa. So it's a little higher standard for the EB1A green card for you to be able to acquire. So let's talk about extraordinary. Oh, let's see. I'm thinking back here. Okay. Yeah. Extraordinary ability. So the advantage to extraordinary ability EB1A, and I'll just focus on this, is that there's no employer sponsorship required, but you must show potential contribution to the U.S. Any occupation can qualify for the EB1A, including entrepreneurs, as I mentioned, and you must show that you've risen to the top of the field and are internationally recognized. Now, for the O1A, similar criteria is required, as I mentioned. However, you typically do need an actual employer sponsored, whether it's an employer independent of you. But in the case of an entrepreneur, you can actually set up a company in the United States, or if you have a company that's already operational in the United States, that company, even if you are 100% owner of the company, can sponsor you as an entrepreneur to come to the US and get an O1 visa in order to manage or operate or lead your company. So if you start out with an O1 and believe you can provide the evidence to meet that criteria, you still will need to have a company sponsor here in the US. So, make sure that you have had that started up, at least form the company, which is fairly easy to do in the US, and have that company actually submit the petition on your behalf, along with the evidence to prove that you are one of the top entrepreneurs in your country. The other aspect to know about, and when we talk about top entrepreneurs, is that what we're looking at is a national recognition. So if in your town you are considered, your business is considered one of the top businesses, that's not going to be enough. You are going to be compared, or the USCIS wants you to show the comparison between your business and your entrepreneurship and other entrepreneurs on a national basis within your country. So this can be done, or this can be any country that you are most recognized in. So we're definitely not comparing to US entrepreneurs. What we're comparing to is the country in where you are currently operating your business and most well known for your business. Okay, so next we'll go, in the time we have, unfortunately, we can't go into too much more detail in terms of the specific requirements there, but what we'll talk about next is the EB2 National Interest Waiver. So with the EB2 National Interest Waiver, it's similar to the EB1A. This is a green card application, and it is one of the few green card applications where you do not need to have an employer sponsor you for the green card, or a family member sponsor you for the green card. So as is stated on this slide, with the EB2 National Interest Waiver, there's no specific job offer or employer required, but you must show that you intend to be employed in your occupation. So if your occupation is business, as a business owner, for example, then you must show that that is what your intent is, that you intend to operate a business in the United States, and most importantly, that business will benefit the United States in some way. So for example, if it's going to be job creation because you're going to start a business or operate a business that will create jobs, which might be considered in the interest of the United States, that might be one option. And let's talk a little bit more about that in a minute. But the other criteria you must look at is that you must also show that you're either an advanced degree professional, meaning that you have at least a master's degree or higher, or a bachelor's degree plus 5 years experience, or you must prove that you are an exceptional ability in your field of expertise. So let me just go to this next slide. So what do they mean by exceptional ability in the field of expertise? So if you do not have a master's degree or higher, or if you don't have a relevant bachelor's degree plus 5 years of cumulative experience in your field, for example, maybe if you don't have a master's of business administration, which might be most relevant to an entrepreneur role, it doesn't have to be, but that would probably be one of the most relevant degrees. Or if you don't have a bachelor's of business or some related type of field plus 5 years experience, then you can possibly qualify for EB2 National Interest Waiver if you can show that you have exceptional ability in the science, arts, or business. And in this case, business would be our focus. So how do we do that? These are the criteria listed here. You must meet at least 3 of these criteria to show that you, or to try to prove that you have exceptional ability in business. And that means showing that you've had at least 10 years of business experience, and or you have been a member in professional business associations. You've had high compensation for the work, or high sales or something like that, that shows that you have generated a lot of revenues for your businesses. If you're in a licensed profession, you can show that you have a professional license. And if you do have a degree, it may not necessarily be a bachelor's degree or a bachelor's or a master's degree, or I'm sorry, it may not necessarily be a bachelor's degree plus 5 years experience, but perhaps you have a bachelor's degree in itself, then that might be enough. And then also you can show that you have recognition. If you can show that you have significant recognition and made significant contributions to the field of business in your country. So again, if you can meet 3 out of these 6 criteria here, then you may qualify for this part of the EB2 requirement to show that you have exceptional ability in business. Of course, the easiest way would be to have a master's degree or higher, or the bachelor's degree or 5 years experience. But if that does not qualify you, then you can look at the exceptional ability criteria to see if you can meet that one. So what's considered the national interest? This is just a list, but it's not a comprehensive list, because you can sometimes make a case for something that's not listed in this list that might be in the national interest. But essentially, as I mentioned, this has to be something more than a local benefit. So, for example, if you, as a business person, because you're starting up maybe a startup that is going to potentially generate millions of revenue that can be taxed in the United States, and you can also have jobs creation because of your plan to operate or start up a business, then that could be improving the U.S. economy as the national interest. It could be improving wages and conditions of U.S. workers, because perhaps you're going to provide high wage kinds of jobs, or you're going to improve education and training by your business for children, or for other qualified workers. If you're doing a healthcare startup business, and it may be something that's going to be a game changer in improving healthcare, that could be another national interest. And there's some other ones as others. So for example, providing affordable housing. If you are going to be doing maybe a real estate project of affordable housing, that potentially could also be considered in the national interest. And finally, the last 2, improving the environment. So if you're an environmental type of business, clean energy, things like that, that could be another national interest. And then finally, if you actually have government support, not necessarily from the USCIS, but from some other agency of the US government, where they are interested in the project or the services and products that you will be providing as an entrepreneur, then that could also be a very strong indicator of national interest. So finally, the EB2 national interest criteria, there's still more to it. Basically, the proposed endeavor must have substantial merit and national importance. So again, that relates back to the previous slide, where what you will be doing as a business person, entrepreneurship, will be in some way improving an aspect of the U.S. that is in the interest of the U.S., as I mentioned, healthcare, job creation, those types of things. Secondly, you also have to show that you are in a you, with your background, are well positioned to advance that particular national interest, because you have the qualifications, you have a proven track record, you can show that it is highly likely that whatever the purpose is of your business, you are going to be successful. And then on balance, the last criteria, which is more of a legal argument, is that it would be more beneficial to the U.S. For you to be able to pursue your endeavor here and then help improve the national or help improve some aspect of the United States, rather than having you go through an employment situation where you are being employed by another company, and then you would have to go through what's called a labor certification process. So the national interest waiver, the waiver part of it actually is waiving the requirements that you have a job offer and that that job prove that there are no other qualified persons, to U.S. citizens or permanent residents, to take the position that's being offered to you. So for an entrepreneur, that should be fairly easy to prove, because with entrepreneurship, it's not something that you would go out and look for someone to, become an entrepreneur. If you are a company owner, you're not going to go out there and start advertising or looking for someone to be an entrepreneur or a startup. So that part should be fairly easy for an entrepreneur. So the key parts for business owners to consider if you're looking at national interest waiver is to look at how will your business help the United States on a national level, and how you are well qualified to do that. Okay. Next, we'll talk about the L1 multinational manager executive, L1A multinational manager and executive visa. So this is for those who already have a business that has been operational for at least 1 year in another country. So if you already own a business in your home country, and you want to now or start up a company in the United States that will be affiliated with your country, with your business in your home country, then an L1 visa might be an option for you. The L1 visa's purpose is to temporarily transfer a business owner or an employee to the United States to continue employment or operations of a parent, branch, or subsidiary of a foreign business. So, for example, if you set up a subsidiary of your foreign company with the intent of keeping both companies operational, and there's sufficient control, meaning there's sufficient control or ownership between the two companies. So ideally, perhaps the foreign company owns the U.S. company, or you as the owner own 100% of the foreign company and 100% of the U.S. company, then we show that there's a relationship between the two companies. And you as the owner must have been working or operating that business, your foreign business, for at least 1 year within the past 3 years before you apply for the L1A visa. And during the whole term of the L1A, you must continue operations of both the U.S. and the foreign business. So you cannot shut down the foreign business and only operate the U.S. business and continue. That will not allow you to continue with the L1 visa. If you shut down the foreign business, then your L1 visa will no longer be void. So you have to maintain, or no longer, your L1 visa will be void if you shut down the foreign business and do not shut down the foreign business and only operate the U.S. business. So it's important that you continue operations for both businesses during the entire term of the L1A visa. The potential for permanent residence is another benefit. It's not necessarily tied to having an L1 visa first. You can still apply for permanent residence through the EB1C multinational immigrant visa category. However, it is sometimes beneficial to start with an L1A, get the operations going, and then convert, or unless I convert, but change or apply for an EB1C multinational green card. And so let's talk a little bit about that. The EB1C multinational executive or manager green card. Actually, this green card probably takes up the majority of the EB1 green cards that are available each year. There are 3 categories of EB1. There's EB1A, which we'll talk about, or which we have talked about. Then there's EB1B, which is more for outstanding researchers and professors with universities or research institutions. And then there's EB1C, which is the multinational executive or manager. This is the most commonly used EB1 visa. And what it requires is that you have, again, a foreign company and a U.S. company that are related to each other, similar to the L1A relationship. and that both companies are operational in both the foreign land as well as in the U.S. And it applies only to top level managers and executives. So certainly as a business owner, being the CEO of that business, you could qualify as a top level manager or executive. And you also must have worked with the company outside the U.S. for at least 1 year in the past 3 years before you came to the U.S. either as an L1 or any other type of visa. So for example, if you came here as an O1 visa holder, but you still maintained operations in your operations of your company in the foreign company, and you basically now want to apply for the EB1C because you're going to continue maintaining both companies, then even though you did not come in as L1, you can still apply for the EB1C as long as you meet all the other qualifications per the business. So let's move on to the another visa program is the E2 visa program. Now, this is specifically treaty investor visa programs. This is specifically for business startups or business ownership. So you would either, for someone who's wanting to start up a business in the U.S., this could be a good option if you meet the requirements. The main thing, number one, is that you must be a citizen of one of the treaty countries. So a treaty country is a country that has signed a treaty with the United States to allow its citizens to apply for E2 visas. You can find the list of countries that qualify at this website. And it does change as far as the countries that qualify. There's about 50 countries or so, and every now and then a new country is added on. Most of the countries are probably in Europe, some Asian countries, a few African countries, Australia, and let's see. Yeah, pretty much that's it. So if you look on this list, you will find whether or not your country is a treaty member. And if so, then you could qualify for the E2 treaty investor program if you meet the other requirements, such as you must make an investment in a substantial investment in a real operating enterprise. So what is real operating enterprise? That could be a startup company that you form, and you have a business plan to show that you've set everything in place, and based on your projections of revenues, based on your projections of staffing over the next 5 years, you are going to have you have a real operating enterprise. So it's very important to have this is not a visa where you can say, well, I plan to do this. This is something that you must show that you've actually set the wheels in motion so that if your E2 visa is approved, you can start right away in operating your business. So you must get the business up to the point of being operational, not something on paper that you plan to do. Or you can purchase a business. If you find a business in the United States for sale and you get a purchase agreement to buy that business can also be a qualifying business for you to run as an E2 investor. Very importantly, you must own at least 50%. So while you can have partners in the business, your ownership to be a treaty investor must be at least 50% or more. And your intent to come to the U.S. with the E2 visa must be that you're going to be developing the business. You are not going to be working at any other place, any other employment. Your job will be to run that business itself. So similar to that is the E1 treaty trader visa program. This is a little different. It's not as commonly used as the E2 visa, but it does have some a common requirement is that you must be a citizen of the treaty country. So again, you would look on this list that I have on this website or this link, and see whether or not your country has a treaty for the E1 treaty trader program. So this is a little different in that this assumes that you already have a company in your home country or wherever you have started operations, and you have a relationship where you are either selling what you're selling or trading in goods and services to the United States, where more than half of your international trade is between the US and your country. So let's say, for example, if you're in the UK and you have most of the services that you're providing internationally is being provided in the United States already, then you could qualify for the E1 program, E1 visa program. So services can include things like, well, let's backtrack. You can engage in sales of, products. That could be one trade that they're looking at in terms of qualifying for this E1 visa. But you can also be involved in services, so it doesn't have to be product related. So for example, you could be a tech entrepreneur transferring some technology or bringing technology to the United States, or working in conjunction with other companies in the United States where you're selling your technology to companies in the US. Or it could be architecture and engineering services. It could be management consulting or even accounting. It could be more than that as well, but that is some of the options. So it's a wide list of goods and services that could qualify. But again, the most important part is that you are a citizen of that treaty country. Another important part is that the majority of your trade is with the US currently. So you have to show that that's already happening. It's not that you plan for that to happen. You actually have to show that you have had that trade and that volume of trade with the United States. Our next visa, or actually green card option, is something a lot of people have heard about, is the EB-5 Immigrant Investor Program. So this is a program that allows those who are willing to make a minimum investment of $1,050,000, or in certain targeted areas, $800,000. If you are able to make a minimum investment of $800,000 in certain areas, more if they're in areas that are well populated. So for example, in the city of Dallas and most places, if you're setting up a business here, the investment will probably be more like $1,050,000 as opposed to $800,000. But if you're setting up your business or agreeing to set up your business in a rural area or an area that has a higher unemployment rate than the rest of the US, then your investment could be lower to $800,000. So that investment can be into an existing business or a totally new startup business. However, in addition to that investment, that investment must have the potential to create at least 10 full-time jobs for U.S. workers, and that would not include family members. It has to be U.S. workers already in the United States that you're creating those jobs, and not related to you. It also requires that you are actively managing the business. So if you receive the green card, you certainly may do other things, but you must also still actively be involved in the management of the company. If you are going to do this direct investment program where you are actually setting up a company where you want to run the company and ensure its profitability. The disadvantage to EB-5, it is a program that takes an enormous amount of time to get approved. So or your application to get approved. So if you apply, you can expect 3 to 5 years before you even hear whether or not you are approved or your investment is approved. In the meantime, your investment has to be in place. It cannot be an application that says, I plan to invest $800,000 or $1,050,000, you actually have to show that that investment has been made, and that investment has to be maintained all the way through your approval if your application is approved. And even after that, you also will get what's called conditional green card, which requires you in 2 years to reapply to show that you have created the 10 full-time jobs, show that you have maintained that investment. And in that case, you would get your final green card. So it is a very long, protracted process. If the other options we discussed are possible, they're usually better options in the EB-5 program. But for some, this is the only option. The change recently that is positive for this program is that you can, if you're in the United States in legal status, for example, if you're here as a visitor or H-1B visa or some other work visa, and you're willing to apply for the EB-5 program, in most cases, depending on your country of birth, you can also apply for not only the qualifying application, which is called the I-526 application, that qualifies your investment. You can also, at the same time, apply for adjustment of status, which is the actual application to change from being whatever status you're in, whether it's visitor or O1 or H-1B, to change to get the green card itself. Again, though this process is very long, it could take many, many years that you are still waiting for the approval of this application. And while I'm doing this, I want to remind people to go ahead and start putting in your questions if you have any, because we are near the end in terms of the next option, and then we'll go to question and answer. So if you have a question, please be sure to use the Q&A section or Q&A bubble in your platform at the very top of the platform. So the last option that we'll talk about is the International Entrepreneur Parole Rule. So this is a really new program. Although it was first introduced under the Obama administration, it never really took off, or it was never really implemented until more recently under the Biden administration. Under the Trump administration, it was suspended. And so we don't have much of a history of or track record of seeing how these programs are being administered. However, under the Biden administration, the USCIS is encouraging those who believe they qualify to apply for the International Entrepreneur Parole Program. So this, as I mentioned earlier, is a very different option than the green card option and the visa options that I discussed. This is actually not a visa. It's not a green card. Parole is simply a permission. So basically, if you received an IER, International Entrepreneur Rule parole, it just means that you have permission to be in the United States, to work in the business that you have agreed to work in, or to try to, to invest in and to grow the business that you want to start up or have started up in the United States. It does not, once the parole is done, you can extend it, but it's not indefinite. There will be a limit as to how long you can keep parole, and that program could end at any time. Just as it was suspended under the Trump administration, it could potentially be suspended or even eliminated in another administration. But the requirements are basically that you as an entrepreneur must have an active role in the proposed startup business. And you must own, and that means you must also own at least 10% of the startup business. And you also have to show that the company is successful or will be successful by showing that either your company has received a number of successful investments from qualified U.S. investors, and that's usually about $268,000 that you must have received from other, well, $265,000 that you've received from qualified U.S. investors, or if you've received government grants, U.S. government grants and awards to your company, or if you can prove that despite the fact that you don't have the investments or you don't have the grants, you still can, your startup is likely to really take off and be a very strong business. And again, as I mentioned, I've been saying startup. So startup to the government means that before you apply, the company must have been started within the past 5 years, but no older than 5 years. And again, parole is just a permission. Parole is allowed for up to 3 entrepreneurs per startup company. So you can have multiple international entrepreneurs apply for under one company, as long as they can prove that they meet all these qualifications. And the initial approved stay is 2.5 years, and you can get an additional 2.5 years granted if approved. So that is a total of 5 years on the parole. This is an option for those who may have no other option as far as any of the other options that we discussed here. And there are people who are applying for this. So it's something to consider if you especially have relationships with U.S. investors who are interested in investing in your startup company. This might particularly, it's not limited to any particular type of company, but it's probably more ideal for companies that will have a national presence and probably have goods and services that have a national scope and could be pretty much highly successful. Okay, so now we come to the question and answer phase. And I see that we do have some questions here, so I will go through and answer the questions. Again, if you do have questions, use the Q&A chat feature as opposed to the Q&A section as opposed to the chat feature. So if you've not moved your question over there, please do move over to the Q&A section. So there is a very good question here. It says, can you explain more about using the H-4 EAD to start a business? So the H-4 EAD, of course, is a employment authorization document issued to those who qualify, who have a H-4 visa and who otherwise qualify for the EAD. So the good thing about that type of EAD is that there is no restriction on the type of work that you can do. It can be employment or self-employment. So we have seen many persons with H-4 EAD start up businesses or be self-employed using the H-4 EAD. So I believe it is a good option. As far as the con of it is, it is tied to the H-1B worker spouse. So you have to be sure that, of course, as you would anyway, make sure that the H-1B is maintained and your H-4 EAD is maintained, because if you lose any of those statuses and you're not able, if you don't have another status to take the place of that, then, that you could have a business that you could not continue to operate. So I would say that that's a very slight risk of that kind of situation where you would lose that H-1, or if there's a slight risk of the situation where you would lose the H-1B or the H-4, using the H-4 EAD could be a very good option to start a business. Okay, so the next question is it important to have a business plan and U.S. registered company as part of the application for the EB-2 NIW as an entrepreneur? And I would say yes, it is important if you are applying as an entrepreneur. And you actually, although you don't have to have a job offer as part of the EB-2 NIW, that is not a requirement for the government to understand how you are going to benefit the United States or have a national benefit to the U.S. You have to have really things in place so that they can believe that you actually, if you came here with a green card, that you actually are going to be operating that proposed business. If it's not already operational, then you should have everything in place so that the government is confident that you are going to actually work in that business and actually, grow the business and have that national benefit. So you would need to have the U.S. company registered. And in our view, if we're going to apply, we would certainly want to have a U.S. company registered and a business plan, a detailed business plan that will be sufficient for the government to believe that you are going to operate that business and that it will have that national benefit. Next question is, can someone who is an accomplished career person qualify for O1, someone who's worked for a multinational company for 18 years? So yes, I mean, it is possible. It doesn't have to be entrepreneur. An O1 is not limited to entrepreneurs. However, if you're going to qualify for O1, as I mentioned, there's very specific criteria that you have to meet to show that you are considered to be at the top of your field. So whatever work that you've done for this multinational company, whether it's a manager in HR or a technology manager or something like that, whatever it is, I'm just throwing out examples, but you would have to show that in that field of expertise, you have national recognition, not just within your company, but within the professional realm. So, for example, if you are a technology manager, you would need to show things like, well, hey, I've spoken at technology conferences. I have written scholarly articles. I have been involved in a high-level position with a well-known leading institution. There are various other criteria that you could use to prove that. So just by working with a company as a multinational, that alone would not be enough. You would have to show these other professional activities that would make the government believe that you are considered to be one of the top in your field in your country. Next question. Do I need to open and run my business in the U.S. before applying for L1A, or can I apply from my home country and set up when the visa is approved and I get into the U.S.? So it's a very good question. So L1A has two types of application tracks. One is what's called a new office, and one is where you've already been operational. So if you've already been operational for at least a year in the U.S. and you have U.S. tax returns for your company and proof of operations, then you can go on that track, and it's an easier track to be approved on because the government can see that you already have operations going on in the U.S. And so they can issue you a 3-year L1A visa, and you can get that renewed for up to 7 years maximum. So basically what that does is that allows you to be here for 7 years to operate and run that business. And then you can certainly during that time apply for EB1C, for example, to get the green card if you qualify. That's the easiest track to go on. If you have not started up your business, or if you don't have business operations for 1 year, then you can apply for the new office L1A. So the new office L1A does require you to have at least formed the U.S. company, set up the U.S. company as far as the corporate structure is concerned, have its name, its tax ID number. It also requires you to prove that you have an office here. So that's the new office. They want you to have at least a 1-year lease. You have to have a business plan to prove what your operations are going to be, what your projections in terms of revenue and expenses and staffing is going to be. You also have to show, as I mentioned, staffing. You have to also show that you are going to have staffing here. It's not just going to be you coming in, but you will potentially have U.S. employees here who will be assisting you in your operations. It's not a one-person business kind of thing. So the short answer to this is that you have to have opened and started up an office here. Even if it's not fully operational, you have to have at least done the legwork to get it to the point where it's almost operational before you can get the L1 visa approved if you're going the new office route. Next question, kindly clarify whether as a tech entrepreneur, I have to be among the top 10 tech in my country to establish a good chance for O1. I don't know of there's not a criteria of whether you're a tech entrepreneur or any other type of professional where you have to be considered top 10, because that's we don't know who would decide that. So basically what we're looking at is the different criteria that the O1 has, very specific criteria, and whether you meet those criteria. So again, things like, have you maybe as an entrepreneur been chosen for some high-level entrepreneurship programs that are well recognized as top programs, like, for example, well, I don't know of an example, but what I would say is you find a top program, or if you have won awards for your entrepreneurship, or you've been a leading member of an entrepreneur or a business organization, or you have had tremendous sales of your technology, or you've received patents for your technology. All those things are going to be considered. There's really no way to determine whether someone's in the top 10, even if you have a organization that says you're in the top 10. The government here may not necessarily put a lot of weight into that organization's determination of whether you're in the top 10. Maybe if they had really good empirical data that shows maybe you're in the top 10 in terms of sales of your company, that might be something to be considered, but that alone would not be enough to say you're going to qualify, or for the government to say you're approved for the O1. Next question is, can we set up a loan from a bank? So as far as immigration is concerned, I mean, there's no restrictions on getting loans. But if you're asking about whether you can use a loan for a particular visa type, so for example, for EB-5, you can use a loan to qualify for EB-5. There's very specific requirements, whether it's from a bank or a personal loan from some family member. There's specific requirements for that loan to be the way the loan has to be set up. So yes, you can, as part of your investment, use a loan. For E2 visa, for example, you can use a loan. For L1, you can use a loan. So there are options in terms of funding. You can use loans for doing that. Next question, what is the cost of the O1 visa versus the EB1? And what is the duration for the approval? Okay, so the cost is very similar. I can't really speak to fees at this point. If you want to know what our fees are, you can certainly contact us for that. But as far as the application costs, they're very similar. There's probably a little bit more for the EB1. Well, there's more for the EB1 because the EB1 is a green card application. So not only do you have the qualifying application, which is called the I-140 petition and its fee, but you also have either the adjustment of status application fees, or if you're going to process at the U.S. Embassy, you'll have consular application fees or consulate application fees. So the EB1 is going to be more than the O1. The O1, typically you're paying for the USCIS to make a decision on your petition, plus, and that would be it as far as fees in the US. And then you would pay some fees at the US Embassy if you're applying there as well, which are usually a lot less than they are in the US. So I can certainly give you more details on costs if you send me an email on that. But the duration of approval for an O1, typically you get 3 years of approval. And then after that, if you are still with the same business, that you're still running the same business, then it's, or the same employer, if you're in the same employer, then it's going to be 1 year approval. So every year you're going to have to reapply to extend your O1 visa, which can be, costly and time consuming. So ideally, if possible, you would want to look at applying for permanent status at the earliest opportunity. With the EB1, the approval is basically permanent status, so there is no limit on that. You would get a green card, and that green card you can keep forever. There's no renewal. While you do renew the card itself, like you would renew a passport, it does not, there's no expiration on your permanent residence, just like there's no expiration on your citizenship. And the EB-1, of course, as a green card application does, once you get approved for EB-1 and get your green card, you are on the path to citizenship. So if you would like to apply for citizenship, you usually can apply within 5 years of receiving your green card based on EB-1. There's a question, the new ruling on EB-5 saying that we can get a green card in a few months. Is it valid? There's not a ruling. There is a special type of, like if it's a national interest EB-5, not a national interest waiver, but an EB-5 that is in the national interest in some way, where the government feels like it's very important for that EB-5 project to be completed. So for example, if the EB-5 project is building a bridge, or doing a bullet train or something like that, where the government feels like this is in our national interest in terms of transportation, then you can request an expedite. And that usually, from my understanding, can get approved, because if you could, by showing that it is in the national interest to have that expedited. But there's, as far as I know, no ruling that says you get a green card in a few months. Just by filing the EB-5, you have to meet the criteria. Your project has to meet that criteria in order to do that. So what you want to do is to look at different EB-5 projects, and this is not the direct investment project, or it could be the direct investment project if you can show that your business is going to, it's really necessary for your business to start right away to get that project done, and it's going to help with the U.S. interest in some way. We'll just we have quite a few questions, but I'm not going to call for any more. I'm trying to finish up the rest of these. So when we have quite a few good questions here. So it says, can a postdoctoral student own a business and serve as an intern in the business to qualify for the NIW, or what is the best for the student? Well, that's pretty, postdoctoral student, if you can meet the qualifications, whether it's O1, whether it's, if you have F1 OPT, you can start a business with that. If you want to apply for the national interest waiver, there's just many ways that we could look at that, but I would have to have more specifics on your plans and what the proposed business is to determine whether you can qualify for the national interest waiver, or what is the best route for you. So I definitely suggest that you contact us for a consultation so we can talk more in depth about your specific situation. Says, can you evaluate the possibility of obtaining a business visa entrepreneur from Russia now? So, and hello, it's nice to hear from you. So it again depends on the business. There might be some difficulty, especially with some of the political situations with Russia in terms of the embassies being able to process on that end. It's possible to potentially get an approval in the US as far as, let's say, an L1 visa, but not be approved at the embassy. So it's difficult to say. I mean, the qualifications are still the same regardless of what country you're from. However, in terms of processing, in terms of the length of time it will take, it can make a difference being from Russia as well. But please feel free to reach out to me so we can talk more in depth about your specific situation. Next question is, how much is the business expected to grow for the O1 visa category if one is applying as a co-founder of the company? Well, there's not, again, we wish we could have that kind of clear guidance in terms of, okay, we want a percentage of growth or something like that. We just don't have that. It's more, again, of looking at the different criteria that's been established for O1 and seeing how you fit into each of those criteria. Now, one of them can be the growth. One of the things you can present is the growth of the business as a showing that your business that you have already operated, for example, is or your co-founded company has already grown to a certain amount based on your leadership. So that could be a critical role or a leading role of a very well-respected company. That could be one of the criteria you meet by showing the growth of your company. But there's really no hard and fast rule that says we need to see a specific level of growth for you to qualify for O1 as an entrepreneur. So yes, so the question is, how can we be further reached to proceed with more information? So basically, my information is here on this slide, but also you'll receive a recording. And with that recording, you'll also receive our contact information as well. So, but thank you for asking, it's there. I currently run a tech startup business in my country, and we're making a pinch for investment from U.S. investors to scale up our operations. Does this lower or increase my chance at O1? I would not say it lowers your chance for O1. If you do get that investment, it actually could improve your chance, just depending on how much that investment is, and perhaps getting supporting letters from investors, those U.S. investors that talk about why they're investing in your business and how they believe that you're extraordinary business person, those types of things. So it could benefit if you, use it the right way in terms of those investments. Last question, can I apply for the EB2 if I am currently on F1 but have 5 years experience and a master's degree in the field? Well, just based on that specific, yes, you can certainly apply even if you're on an F1 visa for the EB2 national interest waiver, or an EB, yeah, I think you're asking EB2. Yeah, so you can certainly apply for an EB2 NIW even if you have an F1 visa, if you can meet the criteria. Certainly having 5 years of experience or having a master's degree in the field is all you need for the EB2 in terms of EB2 NIW for the minimum qualifications. But then, of course, you have to meet the other requirements as well to show that your work will have national benefit. Okay, well, thank you all again for attending. I'd like to remind you again that this information is general in nature and not relied upon for your specific situation. So if you have questions about your specific case, please feel free to contact us or contact an experienced immigration attorney. Thank you so much again for attending, and I appreciate your interest in our presentation, and we wish you all a wonderful day.